A very warm welcome to Six Pump Court Chambers webinar on piercing the corporate veil. My name's Natasha Hausdorff, and it's my great pleasure to introduce Head of Chambers, Stephen Hockman QC, to address you and to introduce our panelists.
Thank you, Natasha, and good afternoon, everyone. I would like to add my welcome to you all. As you know, you're going to be hearing from three of my colleagues, Chris Badger, Charles Morgan and Gordon Wignall, each of whom is on our website, so you could read all about them and their biographies if you care to take a look. I'm going to ask each of them to speak to you this afternoon for 10 or 15 minutes, and then we will take questions. Now, as regards questions, we'd like you please to write your questions down on the Q&A facility, which is provided for in the Zoom call. Do please let us have your questions, and at the end of the three presentations, we will do our best to answer them. And incidentally, the slides that you're going to see, together with a long paper that we've also produced on the subject of piercing the veil, will be available and will be sent to you after the seminar, so you don't need to feel that you have to take detailed notes. And of course, we shall always be glad to hear from you with feedback and on anything else on which you'd care to consult us. And again, details in relation to all of that will be on our website. And so with that, and with the hope that you will enjoy the afternoon, I'm going to hand over to Chris Badger.
Well, Stephen, thank you very much for that, but it's my pleasure to introduce the first presenter, and that's Christopher Badger.
Good afternoon. I thought that I would try and kick off the debate by considering the criminal liability of companies in a regulatory context. Essentially, there are two competing principles of attribution of criminal liability: the identification doctrine, focusing on the controlling mind of the organisation, and vicarious liability. Particularly in a regulatory context, it is vicarious liability that is no stranger at all to being extended, especially in the environmental field, in order to make criminal law as effective a weapon as possible against, for example, environmental harm. It's not unusual, for example, for subcontractors and the work of subcontractors to result in another company being held liable for their actions. The classic case being that of McAlpine. But there are other examples as well of where liability, criminal liability, particularly in environmental cases, has been extended. Empress Cars covers situations that involve multiple causes. Brock, for example, is an authority where the defendant company had no actual active role at all in the principal cause of a leak. It was a seal that burst, but the court held that that was simply a normal fact of life. CPC is an example of where, in fact, the cause of the problem was defective pipework that had actually been installed in the factory run by the defendants 9 months before the defendant company even bought the factory. So there was no question of them being involved or responsible for the installation of the defective pipework, but nonetheless, criminal liability extended to them. The exception are those mens rea offences. So offences, for example, such as in Regulation 38, where there is a necessity for an intent to deceive. That was the case in St. Regis Paper Company Limited, where the company was not held to be responsible for the fraudulent actions of a manager, where the offence required that necessary mens rea. But what I wanted to look at is really the criminal sentencing process in regulatory cases, because really there's a divergent approach taken when sentencing regulatory cases, and in particular that concerns the involvement or the possibility of linked organisations being concerned in the sentencing process. And this is a quote from the environmental guideline, where it states, normally only information relating to the organisation before the court will be relevant unless it can be demonstrated to the court that the resources of a linked organisation are available and can properly be taken into account. That wording from the environmental guideline, the wording is very similar in the health and safety guideline, although the health and safety guideline does include the word exceptionally. And the wording in the guideline really raises a plethora of potential questions and problems. I mean, it must, simply by the very fact that it exists, go beyond principles of limited liability. But what is meant by the words available? What is meant by can properly be taken into account? Is it a question of being legally available? Is it the resources of a parent, do they have to be open to the defendant company to draw on, or can they simply exist? Is there any connection between whether those resources have been made available to a defendant company in the past? And ultimately, it would appear to be a matter of discretion for the court. So what are the principles that govern the exercise of that discretion? You have to read across to a trio of health and safety authorities in order to be able to discern the sort of current trend that exists in the higher courts. In particular, these might be called sort of the going concern cases. The first on the list is Tata Steel. Tata Steel was a very large organisation which had posted a significant loss, and the Court of Appeal held that the sentencing court was entitled to take into account the resources of the parent organisation when deciding not to make a reduction in the fine to reflect the fact that the defendant company was loss-making. NPS London is an example of a joint venture, a profit-sharing joint venture, but 80% owned by one organisation, 20% owned by Waltham Forest. And again, this is another reference to a going concern. It was essentially stated within the account, or within the accounts, that the resources of the parent company were available in order to ensure that the joint venture was a going concern. And once again, that justified the court not making a reduction for the fact that the defendant company didn't make a profit. The latest case in this line of authorities is the Crown of Bupa Care Homes. And that really re-emphasises the idea of taking us back to well-established principles of separate legal identity. And principles to be applied include that the guideline has to be applied in a way that doesn't infringe ordinary and well-understood principles of company law. And one of the quotes was that if it's generally wrong to take into account the parent's turnover so as to increase the subsidiary's turnover at step 2, that's the assessment of the organisation's turnover for the purposes of finding a starting point, then it is wrong to take it into account to increase the fine at step 3, looking at the organisation's finances in the round, absent some special factor of the type identified in Tata Steel or NPS London, these cases being where fines were not reduced. What's notable about Bupa, of course, is that the court declined to try and identify what such special factors might actually be in practice. Another important area in the criminal sphere is that of confiscation. And then particularly interesting is cases that have attempted to attribute the entire turnover of the offending organisation to be a benefit figure, and where they have attempted to pursue the assets of the directors as available assets for the purposes of paying confiscation. So Sale was a case involving a corrupt relationship with Network Rail. And this was a case where the concealment principle applied. Preston Petrodell's concealment and evasion principles. Evasion wasn't met in the case of sale, the concealment principle was. But the proportionate approach to dealing with confiscation was not simply to attribute the entire turnover of the organisation to the benefit figure, but to try and work out what the market advantage was gained by the company as a result of its criminal offending. The next case, Boyle Transport, that re-emphasised really the need to focus on the specific facts of each individual case. The test isn't simply one of justice. The court said that that would be an unprincipled concept, but in fact, one has to go back. You can't simply ignore the established principles of separate legal liability. Third case, Powell, again, reiterating those well-established principles. That was a legitimate company that had broken the law. Rather than a company set up for a wholly illegitimate purpose on the outset, it was a legitimate company that had broken the law because it failed to follow the relevant environmental regulations. And in those circumstances, it wasn't right to try and attribute the assets of the individual directors to the available amount that might be recovered by confiscation. So, how do you advise clients? What are the appropriate questions to ask when you are looking at the interrelationship between parents and subsidiaries in the context of criminal offending? Well, I've set out some questions. To what extent does the parent company oversee the functions of the subsidiary? Is there an overlap between directors of the board at parent and subsidiary level? Do the parent and subsidiary operate in the same industry? Is there an overlap in procedures? To what extent can there be superior knowledge on the part of the parent? This perhaps critically, to what extent are the finances of the parent and subsidiary interdependent? And that goes back to that issue of being a going concern. What control does the parent exercise over the subsidiary? To what extent does the parent supervise the functions of the subsidiary? And those questions really draw on a lot of the issues that are noted in civil law that Gordon and Charles are going to touch on shortly. But it's important to note, I think, as well, that the relevant principles can be distorted by the application of directors' duties under the Companies Act. And so just to give you an example, there is a duty to promote the success of the subsidiary, the company. Now that may necessitate financial assistance from a parent organisation or a linked organisation. And that's potentially capable of clouding any assessment of financial interdependence. And that is where I wonder where the flaw is in this assessment of resources being made available to a subsidiary to ensure that it is a going concern. Because that may not be a matter of choice, that may be a matter of duty on the part of the parent. I mean, in those circumstances, as I say, you can have a situation where the resources of a parent are being made available to a subsidiary company, but which really ought not, in practice, to be taken into account in the sentencing process. And I think one of the issues is whether or not the approach that's taken towards linked organisations and the assessment of going concern or economic reality can actually be said to be consistent with either the application of the concealment principle or indeed the application of the evasion principle. Thank you.
Well, Chris Badger, thank you very much for dealing with criminal offending. Moving to the civil side of things, Charles Morgan is our next presenter. And as I invite him to the screen, could I remind you all, ladies and gentlemen, that you can start putting your questions into the Q&A box, which appears when you hit the Q&A button at the bottom of your screen. We've had a few questions in advance, which we'll be starting with, but then the panelists will move on to take your questions. So Charles Morgan.
A very good afternoon. Welcome to the seminar from my vantage point. We can certainly offer you a variety of insights into this problem, which more than many straddles a wide area of law. Chris has been able to address the criminal point of view since his career began in the practice of criminal law. My career began in the practice of Chancery and Commercial Law, and Gordon Wignall, from whom you will hear next, is a specialist in the law of nuisance. And in each of these areas, this problem can arise. I'm going to address it from the point of view of civil law, in particular contract and tort. But let's go right back to first principles and the case that we all know about but have largely forgotten about, Salomon and Salomon. Decided in 1897, when the courts were struggling with the most fundamental questions about the character of these newfangled things called limited liability companies. And as you'll see from the headnote there, in particular, the terribly difficult concept of a one-man company. How could one person have two personalities? And Lord Macnaghten addressed the question of one-man companies and said that he felt that it was misleading, and the important part of that passage is the bit I've emboldened here. If it merely means that there is a predominant partner possessing an overwhelming influence and entitled practically to the whole of the profits, there is nothing in that that I can see contrary to the true intention of the Companies Act 1862, or against public policy, or detrimental to the interest of creditors. Well, I'm not sure how that last proposition's worked out in the subsequent 120 years, but there's where the propositions are originating. And Lord Halsbury put it this way: once the company is legally incorporated, it must be treated like any other independent person, with its rights and liabilities appropriate to itself. The motives of those who took part in the promotion of the company are absolutely irrelevant in discussing what those rights and liabilities are. And that, of course, was the real point that was vexing the lawyers in 1897. Could you say that person only set up that company to make sure that he wasn't liable, so he should be liable nevertheless? And the House of Lords firmly said, no, he's not. The company is at law a different person altogether from the subscribers to the memorandum. And though it may be that after incorporation the business is precisely the same as it was before, and the same persons are managers, and the same hands receive the profits, the company is not in law the agent of the subscribers or trustee for them. Those were the arguments that had been advanced. Nor are the subscribers as members liable in any shape or form, except to the extent and in the manner provided by the Act. So how then did we come to talk about the corporate veil, and in particular the notion that it could be lifted or pierced? Well, so far as I can establish, the first case in which that expression is used is a 1969 decision, Wood Preservation Limited and Prior, where Lord Donovan said, in the course of summarising counsel's arguments, that for this purpose the corporate veil was to be pierced. It then was used in a well-known case in the context of compulsory purchase, Wolfson and Strathclyde Regional Council. And it grew like topsy and was used all over the place as simply being a reason for doing that which it stated. In other words, you just said, I'm going to lift or pierce the corporate veil, and you did. And it really became a self-invoking principle, and sight began to be lost of the decision in Salomon and Salomon, and sight began to be lost of the need for a principled approach to this concept of looking behind the corporate veil. And then it was all pulled together in Prest and Petrodel Resources Limited in 2013. That was a case concerning the division of matrimonial property on divorce. There's another area of law in which this principle is important and has contributed to the recent most authoritative decision. Now, the ratio decidendi of that case is the disapproval of the prior practice of the family division, and only the family division, of treating the assets of companies which were substantially owned by one party to the marriage as being available for distribution on divorce, as if they were the assets of the spouse, provided only that the remaining assets were sufficient to satisfy the company's creditors. Well, Lord Sumption got stuck into this, and he's a bit of a Marmite character, views very strongly upon him, but for my part I think he has brought a very clear insight into the fundamentals of a number of principles of law, and this is one of them. Lord Sumption acknowledged that a limited power to pierce the corporate veil in carefully defined circumstances is necessary if the law is not to be disarmed in the face of abuse. Well, of course, that of itself is just as general as everything that went before, but he did go on to identify what he believed to be, and which we must now regard as being, the true bases of the doctrine. The first is what Lord Sumption termed the concealment principle. That is, where the interposition of companies is in order to conceal the real actors, to hide the people who are really doing whatever it is, usually fraud. He described that principle as being really legally banal and not involving piercing the corporate veil at all. He next identified the evasion principle, which is that the court may disregard the corporate veil if there is a legal right against the person in control of it, which exists independently of the company's involvement, and a company is interposed so that the separate legal personality of the company will defeat the right or frustrate its enforcement. This begins to look as if it's almost a motive test, which I don't think is the right way to approach it. And perhaps the greatest assistance from Preston Petrodel is Lord Sumption's list of circumstances in which what is termed the piercing of the corporate veil is achieved by the application of other independent legal principles, wherever the circumstances and facts permit. The first of those is the personal liability of the individual, or we'll say the people behind the veil, as agents or joint actors. The second is the principle of trust or nomineeship, where in rare circumstances the company is to be, or should I say specific circumstances, the company is to be treated as the trustee or nominee of somebody else. As we saw from Salomon and Salomon, that is not the default position, as we would put it in this digital day and age. The third situation is where there is, for specific statutory purposes, responsibility for the acts or businesses of associated companies. The fourth is in the award of equitable remedies, such as injunctions or specific performance, which may be necessary to require the controller of the company to act in a certain way in order to cause the company to do that. So let's now look at, very briefly, at the principles as applied to, firstly, the law of contract and then the law of tort, because just as those two areas of law are founded on different doctrines and principles, so is the manner in which they impinge upon this area of law and the identification of corporate liability. Contract first. Now, in VTB Capital PLC and Nutritech International Corporation, the Supreme Court quite firmly reasserted the principle of the strict confinement of liability to the parties to the contract. So for that reason, an agent is only liable in very restricted circumstances, for example, when acting for an undisclosed principal. Merely becoming an agent of the company does not render you personally liable. And again, that is pure Salomon and Salomon. A company related to a contracting party may be rendered liable to repay money or return property on other principles. Again, you've got to find some other principle. You can't just say it's lifting the corporate veil, because that isn't really a principle. It's a description of what you're trying to do, but you've got to say why. And the examples given were constructive trusteeship. We could give a long lecture about that, or tracing, either at common law or in equity, in respect of specific impeachable transactions, where you can say for specific reasons that those remedies are open. You can't just apply them across the board and say that you can always trace a company's money into its shareholders' or directors' pockets. In the law of tort, we start from a different point of view, which Chris mentioned briefly in his delivery. Torts are usually the result of the act or omission of a human being, and it's the liability of the company which is secondary and vicarious. The classic example being the act of an employee of the company, or the omission of an employee of the company in the course of their employment. And there, and this site is often lots of this, it is the responsible individual who is primarily liable. For example, the negligent drive of the company vehicle. But of course, insurance practice would be, in those circumstances, for obvious reasons, always just to sue the employer, and nobody ever really thinks that they are alleging a vicarious liability. A director might incur personal liability, but not simply by exercising normal control through the constitutional organs of the company, i.e., in a director's case, principally decisions of the board, or acting in accordance with such control as the shareholders can exercise in general meeting. In tort, this was really looked at very carefully in Adams and Cape Industries in 1990, and there was there a very firm rejection by the Court of Appeal of the single economic unit principle. As Lord Justice Roskill said, every company is a separate legal entity possessed of separate rights and liabilities. And he warned against disregarding the Salomon principle. And there is no presumption that the subsidiary is the parent company's alter ego. If a company chooses to arrange the affairs of its group in such a way that the business carried on in a particular foreign country is the business of its subsidiary and not its own, it is, in our judgment, entitled to do so. Neither in this class of case nor in any other class of case is it open to this court to disregard the principle of Salomon and Salomon merely because it considers it just so to do. Gordon Wignall will next tell you how that applies in the environmental context, where what Lord Justice Roskill was addressing is precisely what people were trying to do. And he reiterated there on the facts of that case, the court's refusal simply to lift the corporate veil. He said whether or not this is desirable to form groups of companies and give them separate responsibilities, the right to use a corporate structure in this manner is inherent in our corporate law. The case of Cox and Ministry of Justice might be a foot in the door there, where the Ministry of Justice was held vicariously liable for the negligent acts of a prisoner working in the prison kitchen. The Supreme Court said there that the essential factors for vicarious liability were a tort committed as a result of activity undertaken by the tortfeasor on behalf of the defendant, an activity likely to be part of the defendant's business activities, and the defendant creating the risk of a tort being committed by choosing to carry out that activity through the tortfeasor. Now that is a gift on a plate to lawyers in the next case, as it were, because those propositions are expressed very widely and may enable the rendition of people liable in circumstances which were perhaps not intended when those words were uttered. That concludes my contribution. I will now cease to share my screen and return you to Natasha, who will introduce Gordon Wignall.
Well, Charles Morgan, thank you very much indeed for that. And our last presentation is being delivered by Gordon Wignall. Take it away.
Well, hello everybody. It's a great pleasure to be here, certainly, but also a pleasure to be with you. I am indeed going to try and pick up on some of the comments made by Charles about the use of tort law. And in particular, I'm interested in the other end of the telescope, how it's possible to use the principle of the assumption of liability to try and demonstrate that the real party responsible was the parent company. So this is a valid response to Preston Prest. Preston Prest tells us by Lord Sumption that you simply can't pierce the corporate veil. And in that case, can you make the parent company responsible because it's assumed liability for the acts of its subsidiary? So that's really what I'm going to look at. And I'm also going to look at the possible use of economic torts, conspiracy, use of unlawful means, to try and unpick circumstances where somebody has tried to evade liability by way of evading proper enforcement steps. So that's really where I am. That's what I intend to do. So the first question for me is, how did we get to this position of, in particular, assumption of liability, trying to make the parent company actually liable, whereas you might ordinarily think that it was the subsidiary company? So for me, I'm going to go over some of Charles's points. There are some basic principles which seems to me are very important, which have fashioned some of these steps. So the key points to take home for me on Preston Prest are, first of all, the principle that where there is a concealed actor, then that person is the true defendant. This is the principle of personal liability, which Charles spoke about. And secondly, where a person has the power to provide an equitable remedy, then that person is the proper target of a claim. Now, this looks at relief. If there's someone who can give you relief for the wrongdoing, then you should head there. And that's the case of Guildford that Jonathan Sumption talked about, and the case of Jones and Lippman. These are specific performance and injunction cases. So those two are really, in a sense, quite straightforward, but they warn people as to the way in which they should approach these cases. It might have been looked at as cases of piercing the corporate veil. So the other principle, which is a take-home principle from Preston Prest, is the one that says that it's not an abuse for a legal liability to be incurred in the first place. That is corporate liability, pure and simple. Now, if that's right, there's no point concentrating on a subsidiary, and in any event, the subsidiary might not be good for the money. So let's have a look and see if we can hold the principal liable. And then the more difficult question, the much more difficult question, it seems to me, this is the question, it's an abuse, the statement, it's an abuse to use corporate personality to evade a liability, to evade enforcement. The evasion principle, and that is a principle which I look at when I come on to the case about conspiracy. So, moving on. The material case, picking up from Adams in a way, about establishing an assumption of liability is the case of Chandler and Kate. This is just before Prest, but the court was very careful to say we're not trying to pierce the corporate veil. The court went right back to basic principles, Caparo and Dickman, Dorset Yacht and Home Office. You'll find that these are principles which are discussed in detail in the more recent post-press cases. So the real question is there an assumption of responsibility, foreseeability, proximity, and is it fair, just, and reasonable to establish liability? But if you are going to establish responsibility on the part of the parent company, these are very fact-sensitive cases, albeit that you may not have a lot of material to play with, as it were, if you're a claimant. So that in Chandler and Cape, this is about liability for the spreading of asbestos dust. The Cape itself had bought another company originally called the Uxbridge Brick Company, but had slowly, bit by bit, step by step, tried to appropriate that company into its own mould. And indeed, the subsidiary company was making asbestos itself. So you can see these are very fact sensitive because we're trying to make sure that the overarching principal company is really doing what the subsidiary company did. Now, at the end of this case, the court set out what it referred to as a number of indicia which might make the principal responsible. They run like this: the business of the companies is the same. Secondly, the parent has superior knowledge about health and safety aspects of the industry. The subsidiary system of work is unsafe, as the parent company ought to have known. And the parent knew or ought to have foreseen that the subsidiary of its employees would rely on using that superior knowledge for the employees' protection. So these are specific questions, only indicia. Court made it clear they're only indicia, which you can use to establish liability. Charles was kind enough to say that I was supposed to know something about the law of nuisance. You can see this is the sort of case where nuisance and negligence overlap. And we see that a lot more in the cases which pick these up. These are the big cases about what happens abroad in Zambia, Congo, other places. These are often health and safety, but also pollution cases. You'll remember Vedanta Resources was a very prominent case which went to the Supreme Court recently. These are all relevant cases in which the assumption of responsibility principle is examined in great detail, because the point is you need an anchor defendant under Article 4 of the recast Brussels regulation. You need your anchor defendant, and then you've got a case of bringing in the company in subsidiary company elsewhere. So that is why these cases attracted a lot of attention. Now, Chandler and Cape held open the prospects that it might not be too difficult to establish liability. But these various cases, you'll see that I've ticked some in red. So the two in red finally didn't get through. Vedanta did get through. It's a very important jurisdictional case, but it got through really because the English court still thinks that certain countries in Africa are not able to provide access to justice for defendants. So you'll see 2 out of 3, 2 lost, 1 succeeded eventually, with a lot of judgments, first instance courts and the Court of Appeal. So there's a bit of a step back. You'll see these are principles we can extract from these cases. There must be some precise actions or commands which really affected the claimants in these cases to establish liability, not just some vague duty, such as moral duties or an intention to ensure there's no harm to the environment. These would be too vague. There must not just be central policies to determine best practice, there must be centralized control affecting local policies, because you can't really have companies which set out aspirations for the foreign subsidiaries to observe and then say they're liable if they let those the way of operating those policies open to the subsidiary companies. Just because there's consistency throughout a group by the exercise of policies, this doesn't make the principal in this country liable. And then it's an important factual question: what in fact are the local plans and policies, and what is the local staff knowledge? So you see, again, these are very fact-sensitive questions, albeit in a jurisdictional dispute. You wouldn't really have much time to present these before a court. So Vedanta itself, this is the one we heard of last because it went to the Supreme Court. The starting point, again, Chandler and Cape, is the three-party test of foreseeability, proximity, and reasonableness. The indicia are relevant, But the first indicia in particular is not one slavishly to be observed. We must look at the knowledge and expertise and how it was exercised. So that is the last word, and that really reiterates what those other cases we looked at said and what the lower court judges had said. Now that leads me on to the second question. So my first question there is a response to Preston Prest. The second is the question, how do you deal with cases where someone tries to evade enforcement by setting up a lot of systems in the way? And these are cases where the establishment of liability is difficult. They go back to the economic torts of using unlawful means to perpetrate a conspiracy, to avoid a result you don't want to avoid. Before going there, it's important to remember that you must look at the actual statute where it's available in criminal and regulatory context, because you often find an environmental, indeed in other contexts, any regulatory context, you often find that there are specific means of enforcing against other people. So we find that in the Environmental Protection Act, where you can take proceedings against entities who wouldn't originally be responsible. We can see it in the Financial Services Markets Act, where there are means of obtaining remedies against people who aren't obviously responsible, people down the chain. Now, the particular case that interests me, which I hope you will have a look at later, but it's a long case, is this case of Palmer Birch against Lloyd, actually reported in 2019. And this was a case in which the court decided that two defendants, this was a director and a shareholder, conspired together to bring about the repudiation of a contract entered into by a very undercapitalized company, the sort of thing we'd look at and we'd think, well, how are we going to get behind that? Because it never had any money at any stage. There were no Insolvency Act proceedings, and the court decided that if you look again at the facts carefully, then it was possible to use the unlawful means conspiracy to show that the shadow director and the shareholder were in fact liable. So that is a way which has been developed after Prest, a way of getting around the so-called evasion principle to use a means of getting a remedy where someone has tried to evade enforcement. So Natasha and Stephen, thank you very much. That's all I want to say. Thank you.
Well, thank you, Gordon. I'd now like to invite all of our panellists to the screen because it's time, ladies and gentlemen, to move to your questions. We have had the first question in from the Q&A option. Gentlemen, in respect of tort liability, is Chandler and Cape still good law?
Hello again, everyone. I think to a large extent that Gordon has answered this question, but in his admirable presentation. But Gordon, do you want to deal with that very quickly? Is Chandler and Cape still good law?
Well, it's an excellent question. It's a really very good question. I hope it is answered by the further cases. And I told you why I thought that there has been some detail about Chandler and Cape itself in the further judgments, when you might say there's a bit of an attempt to move away from the general principles set out in Chandler and Cape. But this is a bit unfair on the Court of Appeal in Chandler and Cape, because they made it perfectly clear before they referred to the indicia that these are only indicia, and the actual merits of the cases will matter. Now, the first instance case in Chandler and Cape is Win-Williams. And I would think that when Win-Williams heard these vague facts, and they were vague facts about liability and asbestos, then it was going to take him a lot to, if I may suggest this, to not to find that the claimant should recover. But I'd be interested to hear what Charles has to say about this as well, because I suspect that he may have some other gloss to put on it.
No, I don't really have anything to add to what Gordon has said. I think so much water has passed under the bridge since Chandler and Cape that it would be prudent in approaching any future case to use it simply as perhaps as a starting point, but to be very alert to the more recent articulations of principle. I think things in that sense have moved on generally.
Thank you, Charles. And that gives me an opportunity to repeat something that I said during my introduction, which you may or may not have heard, which is that the excellent slides that the three speakers have been using will be sent out to participants along with quite a long paper that we've also produced. So if you want the references to the cases that follow Chandler and Cape, including Vedanta, of course, then you'll find those in the slides, and you'll be able to look at all the subsequent cases. So is Chandler and Cape good law? Sort of, I think, is the answer to that, is the strict chancery answer to that question. Right, Natasha, thank you. What's the next question?
So if the concealment principle is legally banal and the evasion principle is the only remaining legal basis for piercing the corporate veil, what is the objective function for taking into account the turnover of a parent company in the sentencing process, where it cannot be said that any form of the liability is actually being evaded?
Right, well, somebody very clever must have drafted that question. I think that's up your street, Chris. Over to you.
Well, I mean, if you look at the going concern cases, I think you have to question whether they're consistent with either the concealment principle or the evasion principle. I mean, one of the phrases that is picked up in those cases is looking at the economic realities of the situation. And my concern is that that's akin to the unprincipled concept of justice. It's sort of assessing what the judge thinks is right in any particular situation, rather than having a principled, objective approach. And I think that that's demonstrated by the fact that the court's trend at the moment is to prevent penalties from being reduced, in contrast to penalties being increased. I mean, if you're looking at the economic realities of the situation, that there should be no reason why penalties shouldn't be increased if you're properly applying that concept. And so I think, as I say, I mean, the guidelines are phrased in a way that is designed to depart from principles of separate legal personality. They're designed to move beyond limited liability. But I don't think that the criminal courts have developed a principled approach to dealing with that issue yet.
Yes, I very much agree with that. I think that what's happening in the criminal courts is somewhat anomalous for a variety of reasons. The first of which I think is that this is all developed in the context of sentencing cases, and albeit people spend some time on the sentencing aspect of environmental and health and safety cases, no court is going to thank you for citing to them the list of authorities that we've cantered through for the purposes of these talks. And nobody's really picked the fight head on, saying in a criminal sentencing context, hang on, you can't do this because of all these authorities to the contrary. So the criminal courts are proceeding simply on a gut feeling, and of course a gut feeling that is driven by remarks in sentencing guidelines as their ultimate source of justification. So I think there are some big arguments to be had in the criminal context.
You're quite right, Charles, save on one point, which is that in a case in which I was involved about a year ago, a case called Faltec, which went to the Court of Appeal, we did actually take the point on, as I think you put it, and argued that the trial judge had been wrong to take into account the resources of a linked organisation. But we didn't go into it in huge detail. And the result, as you say, is never very satisfactory on the basis of the law as it is at the moment. Undoubtedly, there will come a case where issues such as the extent to which the parent was complicit in the offending might arise, and it seems to me very improbable that one could base anything on that, because after all, if the parent had been complicit, then the parent would presumably have been charged. Equally, a case might arise in which the issues that we've been discussing today might feature in the argument, but that, as you say, that hasn't happened yet, and that's a case yet to come. Right, I think we've got time for one or two more questions, Natasha, if there are some.
Well, we've got a final question here on, well, can the corporate veil be pierced by capital share maintenance rules? There's a little bit of an explanation to follow. An example provided of a limited share company which brings on investors for £200,000, issues 200,000 £1 shares, creating £200,000 share capital, rather than issuing fewer shares at a premium. So, for example, 200 £1 shares at £1,000 each. If a creditor sues the company for £200,000, but there aren't sufficient assets to meet that claim, presumably this means capital maintenance rules have been breached. Can creditors sue directors personally? And if the answer is no, is there any reason to keep the share capital figure low, or does it not really matter?
Okay, so thank you, Natasha. We did have advance notice of that slightly complicated question. At least I found it slightly complicated. And Charles, I think that you were going to try and offer some thoughts in relation to it.
Yes, it's a good question in that it does take us straight back to the same fundamentals that were vexing the law lords in Salomon and Salomon. When the share capital is created and people subscribe for the shares, then they also have to pay over the par value of the shares that they are acquiring, or agree to do so. Now, that is very clearly from Salomon and Salomon itself the limit of their liability in respect of the activities of that company. If a creditor sues a company, let's say it has got 200,000, I think was the example given, £1 shares, and they're not paid up, then and the company can't satisfy the judgment, then the creditor can put the company into liquidation. The liquidator steps into the company's shoes. The liquidator can require the shareholders to put that money into the company, and it will then be distributed according to the insolvency rules, with anything that is left for general creditors being distributed pari passu between them. What an individual creditor suing the company cannot do is leapfrog across all that and say, please court, give me alone, since I'm the only one who's asked for it, the right to go straight to these shareholders and collect their unpaid capital on the shares straight from them to satisfy my debt ahead of all others. So I don't know if that answers the question. The other situation is, well, what if the shares have been paid up, but the company no longer has that sort of money there to answer claims? The answer is that it ought to have, and depending on the exact circumstances, there might be some remedy against the directors on the part of a liquidator again. But I can't see that, short of some sort of conspiracy being proved, though it would enable the individual creditor to invoke that wrongdoing directly against the human culprits, so as to render them directly liable to him for the lot.
Thank you. Anything else, Natasha, or have we exhausted our audience?
Well, we've certainly exhausted the questions. I think the presentations themselves were so thorough that is indeed the end of them.
Well, ladies and gentlemen, it only remains, I think, for me, on behalf of all of us, to thank you very much for participating, for joining. We hope that you found it helpful. As I said, materials will be coming through to you, and we very much look forward to keeping in touch. Thank you all.
Thank you.